This is the presentation of Stambovsky versus Ackley, Business 347, presented by Jenny Pittman, Professor Ronnie Chow. So imagine that you're excited about buying a new home, the home of your dreams. Then you hear a rumor that the seller believes the house is haunted. However, the seller or the seller's representative never disclosed this information to you before you signed the agreement and gave a down payment. Is the seller in the wrong? After all, Helen Ackley shared her beliefs of her house being haunted by poltergeists with Reader's Digest and her local newspaper, but could not disclose this information to a buyer. Some may argue that Mr. Stambovsky should have known about this information beforehand, but he was not a local, so he did not hear about the stories until after he signed a contract to buy the house. He was not in the market for a haunted house, and he wanted out of the contract. Parties in this case are Jeffrey M. Stambovsky, the plaintiff, and Helen V. Ackley and Ellis Realty, the defendants. So, some of the facts of in the case are Stambovsky, the plaintiff, alleged that Ackley and her real estate broker, defendant Ellis Realty, did not inform him that Ackley believed the house was haunted. Ackley shared her beliefs with her community and the general public through articles published in Reader's Digest and the local newspaper. Prior to closing, Stambovsky learned about the house's reputation and unsuccessfully sought to rescind the $650,000 contract of sale and get back his $32,500 down payment without resorting to litigation. Stambovsky alleged that he would not have entered into a contract if he had been informed of the alleged poltergeist activity. Stambovsky is suing for his deposit of $32,500 and to be able to terminate his contract. Owners now, because of this ruling, because of the Ghostbuster ruling, they need to disclose if a house is allegedly haunted. So, Ghostbuster ruling. Before the infamous Ghostbuster ruling, New York law did not recognize remedies for damages due as a result of the seller not disclosing information or keeping silent. New York followed a strict rule of caveat emptor. Caveat emptor is the principle that the buyer is solely responsible for checking quality and suitability of goods, in this case a house, before a purchase is made. Okay, so let's go over some of the issues here. So the defendant contended that the as-is clause bars the recovery of the buyer's deposit and also prevents the buyer from terminating his contract. So there are times when a seller may not want to have a property inspected or provide a warranty for the property, or maybe they just want a quick sale. So in these cases, the seller can add an as-is clause to the contract. This will simply state that the buyer will agree to purchase the property with any defects that may have already been present. In this case, poltergeist activity, which was apparently claimed by the owner and not disclosed. However, this does not mean that the seller is not liable for failure to disclose any defects that may not come about from an inspection. And again, in this case, a poltergeist activity. Now, the basic law on as is that the seller is still liable to disclose any defects. Now, the court also stated that not even the most thorough or meticulous inspection could have exposed the presence of ghosts. It could also be said that the defendant did not deliver a vacant house as stated in the contract language. So initially, the Stambovskys lost their case, but won in an appeal. The court ruling was known as the Ghostbuster ruling because of its reference to the Ghostbuster phrase, who are you going to call? And the court realized that there was no inspection that could have uncovered the alleged haunting. If Helen Ackley could disclose her beliefs of the house being haunted to the local community and the Reader's Digest, and even include her house in a 5-house walking tour, then why not disclose this information to someone interested in buying the Victorian home? You cannot say that she misrepresented the home, but she did leave out key information to potential buyers. In this case, the fact that she believed there was poltergeist activity, and this could have changed things had Mr. Stambovsky known this information prior.